glad to see you. Do you hear me? Firstly, just to check.
Yes,
yes, we can hear you fine.
Okay, perfect. Okay, that's perfect. I'm really honored and that I have this opportunity to participate and to hold as a, let's say, kind of guest lecture today with my dear colleagues, your main professors who will examine you, Professor Krstić, Ivana Krstić and Tanasija Marinković. As I teach general EU law, first I would like you to invite you even later if you need some help about papers, about literature, whatever you need. I mean, you will work later on your seminar, maybe seminar paper, I'm not sure about that, but of course on your master thesis. And please don't forget that I'm here, and please write to me. We will keep in touch, and I will gladly help you with whatever you need from this main general actually EU law area. So I understood here we have some colleagues of yours. We will wait for 2 minutes more, maybe one more person, and I will use this opportunity to put here presentations. PowerPoint presentation. I will after this class. I will send you all the materials I prepared. Please don't afraid; it will be maybe a lot of them, because and just keep it. You can open a folder named EU law and EU and gender law, EU. How to say, Court of Justice of the EU law and gender, and because today we will speak a little bit. We will tackle of three main aspects which I prepared. But as you know, you will have a couple of exams, and you will write some essays, maybe analysis. We will have the analysis of judgments or something like that. I'm still not. It depends of your professors who will examine you, but you can use these materials later. Of course, it will be also on our site for launch. So let's. I will just see where is the. So how to. I shall. Today we will start with some of the. Izvinjavam se. Do you hear me? Is it still okay?
Yes, it's fine.
Okay, perfect. I will just put this down. Okay, and I will ask you, do you see now the first presentation? To not summary, nego ovako ćemo. Can you a little, do you see more or less the others? Do you see online?
No, it's not visible.
No, it's not. So I'm on the just to put the video share content echo. Okay, this is. And now is it better? Do you see?
It's currently loading. Yes.
Yeah, okay, perfect. Yeah, it's coming. Okay, so how to maybe so many. This will go down. Show video view. Okay. Okay. So and here. So probably one more student will come, but I suggest let's give it. And how are you used to work? Do you? It depends on professor, I suppose. But I would like to see with you for the breaks. Is it fine to you? Maybe maybe to work with only one break and to finish a little bit earlier. Is it fine for you? Just tell me. It's really, I would like to always to discuss with you. Yeah. If it's fine, maybe we don't need to to spend the whole evening here. And I was thinking I share a little bit context in maybe to work into a little bit longer courses. Okay, let's see here. So first one, if I understood the yeah. Okay. Here we have. I'm sitting here with the lawyers. For the others, if I understood, you are not all of you. You are not lawyers, right? The others, hopefully you can follow. But if you need some help later, we will keep in touch. And please interrupt me if you don't understand something. But I would like to tell you, we can manage somehow to have consultations after this class, because I'm looking as a kind of guest lecture, and I can give you for the others, who are abroad, maybe consultations online like this, especially for those who will have a little bit difficulties with the two courts, or who are not. Who don't know very well EU law, international law, and all this stuff, as other colleagues who were students of Faculty of Law, maybe. So please count on me, and I will explain you later whatever you need, and you can come here at the faculty, or we can work online for that. So our first title and the first subject today will be, as I understood, Professor Krstic and Tanasi Marinkovic worked a little bit. They focused on Strasbourg Court. You were analyzing a little bit judges of the Court of Human Rights in Strasbourg. So today we are going completely. We will talk about the case law of the Court of Justice of the European Union. As you know, this court has a very, very vast and huge case law. This jurisprudence is, do you know where we can put, is it secondary, primary law when we are talking about the jurisprudence? Yes. So if we have a judgment of it depends. Do you know maybe how many judgments, just to see, because it's quite different in Luxembourg court. We have how many judges is sitting in, how many? 27 in the Court of Justice of the European Union. And do you know how many maybe judges are in the General Court? Previously, do you maybe remember how it was? No. They had a huge reform from 2000 till 2009. For 5 years, it was whole. Actually, court was had a reform, and it was 27, but today it's double. Every member state has 2 judges. So it means how many? 54 judges are sitting in General Court in Luxembourg. So we are talking about this, especially this court. Before this reform, we were talking about another one, third one, but do you remember maybe? Exactly. Civil service. Yeah, but all these judges actually moved to this General Tribunal. Okay, so today we are talking about the case law about this of the Court of Justice of the European Union. As I said, there's the jurisprudence is really huge. There are so many different judgments related to the gender law, of course, but in the first, let's say, 20 minutes, I will just show you, for example, what's the situation in one area. It's a special area, judicial cooperation in criminal matters. It's the actually third. If you remember, there are three pillars, and in the third pillar, it's actually the area where the firstly show this kind of the jurisprudence. So we will go to quickly through the introduction. I will give you the historical content. We will go a little bit. We'll talk about normative framework. We have where we have judicial cooperation in criminal matters, and we will go to this gender law perspective. And of course, I will just
Professor.
Yes.
Sorry, are you changing slides on the presentation?
Oh yeah. Sorry. Of course.
We cannot see that. We just the first.
Yeah. I'm still. I'm talking about the content. Thank you very much for this. And don't worry. I will. As I said, I'm sorry, but a little bit bomb you with the materials. But put everything in one folder and keep it for later. Maybe you will need something, and you can always find a different cases from this. I don't know, whatever you will work later. So I will try. You will have 3 presentations for today. The colleagues of yours, I prepared some essay discussion question, but it can be essay if you are maybe more interesting who is interesting to write the answers, and you can send me, and some tabelas, but you will have everything on email during the weekend, and please don't afraid, as I will not examine you. You will keep all these materials, and keep in touch for the later if you need any help with all this stuff concerning EU law, especially EU law, because till now you were more or less you were dealing with Strasbourg court, and the very waste jurisprudence from Strasbourg. Okay, so the key instruments, legal key instruments, are in this area, in the judicial cooperation in criminal matters, are probably some jurists are actually lawyers already knows, but don't worry, the others will. I will happy with this. We are talking about the European arrest warrant, European protection order, and victims' rights directive. I'm just trying, to see. Yeah, it's not to zoom here. There's so many. I'm afraid not to just to see. There's so. Right.
Profesor, možda da pritisnete ovaj X ovde sa leve strane i ovaj X sa desne strane.
Hoće se da ne isključim vas koji ste na online. Levo ili desno? Da ovo ugasim.
To, da, i sa desne strane isto.
Odlično. Jesmo i dalje na vezi online, ili jesmo?
Jesmo.
Samo da ugasim vas. Dobro, odlično. So, idemo polako. So we will. So here you can see the key instruments. It's European arrest warrant, European protection order, and human victims' rights directive. Here I took the main, the landmark, landmark cases in this area. It's more or less relevant judgments in this area. On gender law, but especially don't forget we are talking about judicial cooperation in criminal matter, because when we're talking about the EU law, it's so huge, and you have so many different issues in different areas. So today I will try to give you brief analysis of main judgments in last, let's say, in the last decades, or maybe a little bit more, from 2014 till 2015, 2026. So here you can see these are really famous, and they are concerning criminals. So we are here in the criminal EU law, as you know. EU law, it's dealing in all, actually in all areas. So first one, it's common from 2018, Pancharevo 2021. We will talk a little bit later about this one. WAC is from 2024. Mirin, Moose, and very famous one, Delhi from 2025. So it's good to have it, and if you need some to quote or work, you can find. So these are really very representative. Let's go. When we are talking about the, let's go a little bit little bit back. I will give you as introduction historical and legal background. When we are talking about the evolution of gender equality of the EU law, this is a long, as you know, very long journey toward gender equality. But it began, as you know, the three, especially where we are talking about the three main. Do you remember when we are talking about the in 90 when we are talking about the EU, but how does everything started? Which international organizations in that time? It was for Peel and Bravo. Yes, it was in 1952, 1, 2, yeah. Excellent. Yeah. So we are going back to this year in 1957. So in 1957, this treaty, first one was, as you said, mentioned the first community. It was Paris, a Treaty of Paris. So with this one, the second one, the Treaty of Rome, we are talking this treaty in 57 introduced the principle of equal pay for equal work. So this was expanded, especially after the Lisbon Treaty. Today, when we are talking about the EU law, please have in mind we are talking about the which year? It's starting from 2009 to 2009, and it's a current EU law. Whatever you need, you can find in Lisbon Treaty. It's informal. As you know, probably, but I will go slowly. For the others, I cannot go to all the details now, but for the others, no lawyers, I can explain everything later during the consultations. So when we are talking about the Lisbon Treaty, please keep in mind and have in mind that we have actually 3 treaties. It's colloquial, we said a Lisbon Treaty, but actually we have treaty on the, do you maybe know, Treaty of the EU, Bravo, and Charter. And that's very important. Charter of the is the third one, and a lot of protocol declarations, and that's why even for the European jurists, they say it's actually this treaty is like a Frankenstein. It's so huge. Here it's printed version of the Lisbon Treaty, so with all protocols, declarations, 2 treaties which you just mentioned, and Charter as well. And that's why actually the whole, as we are saying, the EU citizens, they have the rich and the very good protection of the human rights, actually the best in the world. If we are going, the whole instances in which can they can firstly what they have, all the national instances. They have Strasbourg Court, and they have Lisbon Court as well, arbitrage, and all the other stuff as the others. But this is very important sources, charter of the charter as well. So this is new actually. So we are talking about the 1957. Over time, this principle expanded the Treaty of Lisbon in 2009, and actually the legal framework for gender equality by merging the EU and the European Community and introducing this actually Charter of Fundamental Rights as a binding legal source. So the judges were using this charter even before, but from 2009 it's binding legal document because it's a part of the Lisbon Treaty. So let's go. Next treaty. We are actually talking about we are still talking about the primary law. Who is signing this treaty? Who are the parties? States, actually, are states, and that's the difference. Let's have the parallel with the secondary. Who is signing who is working on secondary legislation? Who is creator? I mean, the institutions. When we are talking about the secondary, it's regulations, directives. So who is the institutions? European Union institutions. So that's the difference. Here we are still talking about the primary EU law. So that's the highest level, and actually it's binding, of course, and there is on the here she is the highest actually source, and all of them, like say, they split at one moment in Lisbon Treaty, more or less, because these two treaties are 99% of all the others from the others before them. Was just a second, development. Okay, in 1990. The Amsterdam Treaty. Amsterdam Treaty was judicial cooperation in criminal matters was formalized with the Treaty of Amsterdam in 1999 and introducing mutual recognition of judicial decisions. So this area, the area of freedom, security, and justice, further actually solidify this cooperation, and that's why we are talking today about. We have the instruments like the European Arrest Warrant and European Protection Order. So these two instruments are key legal instruments in this area. We are using this, and just to put here, you see the presentation. Key legal instruments are European Arrest Warrant and European Protection Order. So the first one, European Arrest Warrant is central tool for this area for judicial cooperation, allowing for the quick arrest and transfer of suspects or convicted individuals between the member states, between European Union countries. But what is important here, it's not absolute. This actual application is not absolute. The Court of Justice of the European Union has ruled actually that if there is a risk of fundamental rights being violated, such as poor detention conditions or lack of judicial independence, the warrant can be refused, but only in exceptional cases. So there is a list and everything. Only in exceptional cases can be in this special case he can be refused. This is assessed through a two-step test. There is a first one who is identifying systemic deficiency in the issuing country, and second one determining a real risk to the individual in question. And the second one, it's also very important, the European Protection Order. This is an instrument which allows victims of crime, especially survivors of gender-based, because now we are related to this gender law, the gender-based violence, but not only. That's one, because the lawyers know you can use it in the others, of course, area as well. Gender-based violence to transfer protective measures like restraining orders from one EU country to another. So this issue continuous protection for victims who move across borders through the EPO remains underused due to lack of awareness and procedure barriers. So probably with some of my previous colleagues, you mentioned maybe the Victim Rights Directive. Now we are talking about the secondary law. When we are talking about directives, we just said which what we have as a set of secondary law. And for this directive sets minimum standard for the treatment of victims across the EU and ensures access to support services, protection from retaliation, and privacy in criminal proceedings. Here you will have the interesting, actually, the gender law perspective from the EU gender equality framework. I will not go in the details, but you here you can find, for example, the directives which are dealing with this issue, and if you need, you can easily find all these sources. This is important, probably with Maria, you mentioned this gender equality strategy from 2020 to 2025. And it includes actually the Pay Transparency Directive of Gender Balance in corporate boards, and the EU accession to the Istanbul Convention. Because judges, in the recent case law, the judges of the Luxembourg court started and they use actually they are adopting this Istanbul Convention, and they are using it in their judgment. This is very important, and this is new, because it's really recent. In the last maybe 5-10 years before that. With Maria, probably you go deeply, so you know about the Istanbul Convention, which especially will target violence against women. So despite these advances, actually the challenges persist, which are the gender pay gap, lack of paternity, for example, leave, structural disadvantage for women in social security, persistent gender stereotypes, etc. Here I will just go here. When we are speaking about the Court of Justice of the EU case law. Now the question is where gender and judicial cooperation meet limiting grounds of the European arrest warrant refusal. So the court has narrowed the grounds for refusing fundamental rights. Show already the famous, actually, the most famous landmark gender-related cases. The first one is common case. As you see, it's 2018. Then Pancharevo case in 2021. This one was mandatory recognition of a Spanish birth certificate listing two women as parents to ensure freedom of movement. Then we have the judgments for dealing with the second with the same-sex marriages and families, and Common and Pancharo, and the next one is famous recent case. All from the judgment is from 2024, where a Court of Justice of the EU, this one, just to put, where the Court of Justice of the European Union recognized women facing gender-based violence as a particular social group. That's the gap, actually. That's the where there's the group where they can where they're eligible for the status under EU law, aligning with the Istanbul Convention. That's this possibility as well for the victims of violence. Then famous Mirin case, legal gender. This one has legal gender recognition. This case was established in 2024. Established EU countries must mutually recognize gender changes legally recognized in other member states without requiring surgical intervention. So this marks a shift from a medicalized to an identity-based understanding of gender. This one. Judicial cooperation and gender law, shaping how the EU responds to challenges like for example, cross-border crime, gender-based violence, and the recognition of diverse identities. As this area continue, actually, it's completely area which is developing every day. Say the court's role, the role of the Court of Luxembourg will remain crucial in ensuring actually justice, equality, and protection for all individuals, regardless of gender as well. So this was a little story who is dealing with just to have an idea how it's happened even in this area where the member states are supposed they really have to cooperate and they are using these. I show you these key instruments: European arrest warrant and European IPO. So they and you have the list of the main landmark cases, and if you need later, you can just add it. But these are the crucial, the landmark cases. So let's. We will. If you agree, we shall continue a little bit more. And we have a small break later. We can. Then I will now go to the main actually. Equality, gender equality. Sure. Just to put here. Here as well, I need to. Oh, okay. Sorry, this one. Later, this is. Yeah. Okay, so you see. Do you see the others? Please, could you just tell me? Do you see online gender equality jurisprudence?
Yes.
Yes, we can see it.
So this is the main. Actually, we are going. I started with a small area which is dealing with this with the gender law, but this is let's restart. How to say? We are going to the gender equality and how it works. So, firstly, we will, as we are going to speak about the Court of Justice of the European Union and his huge jurisprudence. First, I will check if you know, or at least I will present you something about direct effect of the European Union law. This is important because we are dealing about the primary sources and secondary as well, to have an idea where there is direct effect, which can be vertical, horizontal, and the others to be sure that you have this knowledge. Then we will go to the general overview of the court, general overview of the Court of Justice of the EU positions, then interpretation of discrimination grounds, open issues in the Court of Justice of the EU case law concerning gender equality. I will ask you, did you have the time maybe to read a little bit? No, it's not. But as I said, today I wanted to talk about this famous Rothman case, because it's one of it's dealing with the European Union citizenship. And after this one, there are a couple of others which are more or less same, but different as well. And you will have analysis. I will give you one apologies, but again, this is for your work, actually, for work, or if you can use it later. It can be useful, maybe. If you're interested, you can do it at home and maybe send me, or just keep it. You will maybe find useful for the other later work. So, let's start with so Rothman case, it's one of the most famous. It's a turning point. It's a judgment from 2010. And the other two, which we will deal with, the other two also judgments who are dealing with the EU citizenship as well. You can have a useful comparative, actually comparative table. You can see how does it works in 2000, how does it work in 2000, and how it's developing actually how it's Court of Justice is, and is it, and how is it, why his main role is so important, actually, even in this sensitive area when we are talking about the citizenship. What does it really mean? Actually, we are talking about actually competencies of the member states firstly, and then we have the EU citizenship. So it's quite interesting to see and maybe to compare these two judgments, as you see, Rothman case and this one from 2021, the Seed case. So let's go slowly. I will, if it's in maybe other circumstances, I will ask you, maybe, do you know what is direct effect? What does it mean? But it's really important to understand in where we can where we can find the direct effect. Is it primary or secondary law? In directive, and which one? Is it vertical or horizontal effect? So please keep in mind that there are two aspects to direct effect: a vertical aspect and a horizontal aspect. Actually, to understand the enforcement of gender equality, we must master the doctrine of direct effect. This is a principle of the European Union law in general, and this principle allows individuals to invoke actually the EU law directly before national courts, provided with the obligations which are precise, clear, and unconditional. So these three must be split, and we are these three conditions. So we have two aspects of direct, vertical and horizontal direct aspect. Vertical direct aspect concerns the individual's relationship with the state. So we have persons and the state. While horizontal direct effect concerns disputes between only private parties. Here I will give you the example of two, keep in mind, two very important judgments. First one is one din from 1974. 1974, because there is a directive gap. In this landmark case, one din in 1974, and Rati case, the other one is from 1979. These two judgments, the court established actually that directives, unlike regulations, lack horizontal direct effect. And here we can actually speak about that's why it's important, the charter. The charter is a breach, how to say. Today, actually, this gap is breached by the Charter of the Fundamental Rights. Why? Because under Article 21 of the Charter, the principle of non-discrimination carries horizontal direct effect, allowing it to be invoked in private disputes where a directive would otherwise fall. So this is the main point here. You can see actually why this charter is especially as a third one. We have the Treaty on Functioning of the Treaty of the European Union, Treaty on the Functioning of the European Union, and if there is some issue which is not dealing with these two, you can find it, especially in this area where you're talking about human rights and the all sensitive other important things. You can find it in the charter. Otherwise, we are talking about declarations and smaller sources of this EU primary law. Here you can see actually the it's very, you will have it, you can read it at home, but you can see, we just mentioned all the, can you please repeat which are main secondary sources of the European Union law? Regulations, decisions, and there are two more which are not mandatory. Exactly, opinions and recommendations. They have legal. They don't have legal binding force. So when we are talking of the secondary, we are mainly thinking about these three, and regulations are very important. They are directly applicable in the member states, as well, and directives are acts addressed to member states which must be transposed into national law, and there are a couple of scenarios for that. It depends on every member state. But here, as you see, there are again a couple of landmark cases where you can find the possibility, and where the gender law. For example, I just mentioned the Rati case, Van Din Home, where court in the Van Din laid down in this judgment the directive has direct effect. So when its provisions are unconditional and sufficiently clear and precise, and when the member state has not transposed the directive by the deadline. So, however, it can only have direct vertical effect. And later in 1979, in Rati case, it was actually again the member court said that member states are obliged to implement directive, but directives may not be cited by the member state against an individual. So this is important to have an idea later when you are dealing with and when you are analyzing the judgments, and you will cite some secondary legislation as well. Here you have a general overview of relevant relevant Court of Justice of the European Union court positions. It's very famous. One of the very famous judgments is a Magnol case from 2005. Then De Frene, but there's a couple of parts. This is the third actually judgment, De Frene, in 1978. And again, in this judgment, actually, the court stated actually the position stated in the same in the Frene tree. I will just here split that directives do not have direct effect in horizontal disputes, and again, please don't forget that, but Charter of Fundamental Freedoms does. And that's what is really nice in this EU law. You have so many different sources, and if something is not allowed in one sources, you can find how to say bridge that gap, and you will find the possibility in using the another source of law. So this one is very important. That's a Charter on Fundamental Freedoms, and this principle of protection from discrimination under Article 21 of the Charter. And here we can we will define actually the scope. We are going to the interpretation now of discrimination grounds. You already talked about this but in human rights, and actually you were focused more on the Strasbourg court, actually, when you were dealing with all these issues. But I will give you just an idea how it Luxembourg court, just to have the parallel idea and to have the idea of the other main landmark cases and how was this evolution through the jurisprudence of this court. Actually, when we define the scope, the scope of sex and the intersectionality challenge, the Luxembourg court has transitioned from a market-based view at the beginning of equality to recognizing it as a universal and fundamental right as well. So it's the same, and as they are using today as Strasbourg court as well. So we can talk here about the doctrine, the pregnancy and sex doctrine, where adverse treatment related to pregnancy is legally categorized as direct sex discrimination, a position which was reinforced in this Hackelbracht decision. It's a famous judgment, but it is important from 2019, and it is one of the landmark cases. Why? Because it shows the meaning of discrimination grounds follows from interpretation. It gives this, it's very important for this doctrine, pregnancy and sex. It was confirming in these landmark cases. And what about intersectionality? And now we are talking about the other judgment, which is very important. Evolution actually of all these main doctrines, having in mind that we're talking here, we started from 1957, but as you see, you probably can after this class maybe, and later when you will see a little bit huge jurisprudence of the Luxembourg court, maybe see and analyze, and you can compare the case law of two courts, and you will see that especially in the recent years, EU court, Luxembourg court started and is developing. Actually, they have the very vast and rich jurisprudence in this area. We then we have gender identity protection. Also explicitly applies to gender reassignment, a principle which is established in the after this one, Paris. We have P versus C, 1996, and recently expanded to cover cross-border recognition of identity. So I will not go through all this. You will, if you're interested, if you need, you can find. Really very complex, and today, how to say, it's really huge, a very huge jurisprudence of the Luxembourg court as well. We started with the third pillar, but now we are in the main, actually, gender intersectionality, so many all areas concerning actually gender equality, and they are dealing. We saw at the beginning these 27, but they are not sitting always in this plenum, but the judges of Luxembourg court on the daily basis, they are dealing actually with today that's the case. Before it was not the case, but they are dealing with the gender law. And this part, I'm just asking, do you need maybe because this was, at least this is the most interesting. Do you maybe are you interested maybe to stop a little bit here and to finish later about with the citizenship, and we will analyze. Is it okay for the others?
Okay.
Yeah. Okay. Let's take break for you. Citizenship, and two very, very interesting cases. One is the Rothman and the other. Let's have us. See you soon. Are you just maybe which topic? It's really very much break neki preobični stvari, da se možete spremiti. Znači odmah se nastavlja. Pa gledajte da iskoristite to. Jel možete već sa ovim mandatory courses ovo da krenete? Da. To bi bilo dobro, kogod može da...
Ja znam još žala dva, kako će da izgleda.
Aha, da, dobro, ovi se vode kao kasnije, ali imate ovo.
Znamo, ne.
Ali to će vam reći profesorka, baš detaljno za ovo drugo, jer su specifični. Vidite koliko je ovo, ko može da čita toliki, mislim, toliko je to bogato sve da verovatno će vam dati i analize i neče, da primenite. Da se ja pitam, ili bi bio open book exam, mislim, ako meni, koji smo na ovom generalno, pa mislim, da ne kažem, učimo čuli su to, ali ja kako to svi u ovoj učinu znači. Dobro, vi ste, samo da čitam, vi ste da radite, možda neko radi u ovim domenima?
Ja radim
ovo iz ljubavi, onda, tako je da. Da. Ima, znači, dobro, olakšamo vam. And I want to ask you, why you were interested in this, you're here just for this matter, and the other, I'm here for this, for final instructions and you might make for the conference. That's really what we're doing. In the Urbink, da vam uzmem dalje. Se osvežite i posle dođe. Hoćete ostati vi ovde, da bit će nekog u prostoriji da... Aha. Ok, samo da ne... Da. Nek stoji sve, samo da izvrši. Ovo pitajte, profesor, to znajte, da ovo je specifično. Da, može da menjam kroz svake godine. Da, što se kveti? Ne, pa je nekako, Da, kad dođe, ali prosto igrajte se, zaista će mi biti zadovoljstvo i što više što god ovo treba izvršiti ne. Da prosto se ljudi prava i međunarodno javno i uopšte, ali su specijaliste pa su kad učestvujete, ti su baš za ovo to. Ali ako vam kažem nešto se tipa, upravo posebno ovo nešto, molim vas, javite se, da to da vam budemo koristili, neka se udušite kad ću sad ću vam dosta to. Ovo sve danas, samo tako. Da treba da znate gde je ovo. Nije novo, nije to.
Da se ne bilo za rad, ili ispit, zato što internacionalno
da vam da šaljem putem maila, dođete se uzmemo pa da vam dam ako vam zatreba, da ne znate još ništa čime ćete se baviti, istraživački rad, kakav će biti, pa tom potom se vidimo, koleginica Marija Lajković je baš u tome i on ima i more literature, tako ne mogu to sve slati, ali opet ako se nađe potrebe za bilo čime, samo se javite, baš sam prošle godine slala putem maila i toliko, ne može ni da se mailovi. Da jeste, ali opet, šta znam, da ne opterećujem ni tamo, ako je iz ovog aspekta nekome trebali, imali smo mnogo studenta koji nisu uopšte mogli bez neke osnove da prate. Mi smo tu svi, we are here holding this, but what's the time? Aha, vidite, evo, možemo polako. Sad ćemo na ove nijanse između i ovo. Vezano za... Eto. Samo da provjerim. May I kindly ask you, do you hear me?
Yes, we can hear you.
Okay, hello, because I have the presentation here as well. I don't see the, okay, so it's important. Do you see the PPP? Is it fine? You have?
Yes, it's fine.
Okay, perfect. Okay, so we will continue and we will actually finish for today. In this block. How we can define who is the European Union citizen? Can you tell me who is that person? Who is the
state decide who is a citizen? So, for example, migrants and people who state don't see as their citizen cannot be criminals.
This is very important, dear citizen. But when you say EU citizen, what does it mean? How many member states today we have in EU? 27. So EU citizens are citizens of the member states. Actually, they have to have the nationality, citizenship of one of the 27 member states. Mm-hmm. So that's the beginning of how to say. So and European, and later, yes, you developed already the status of nationals of the member states from which all their EU rights are derived. Have you any idea, we as the citizens of for example, we who are living as citizens of Serbia, we have some rights. Some rights have EU citizens as well. Do we need to start with our rights, or maybe you can tell me? Do you know EU citizens? What are the main rights of the? What does it mean if you have the? What are their benefits when we say is European Union citizen? And is there any duties maybe?
Transportation, the free movement of the
exactly free movement of. Yes, of course.
Or whenever you like, you don't have to leave after 90 days.
Exactly, there are some, of course, but there are some, as you said, it's not without any conditions. So yeah, the otherwise, maybe the other.
The be employed, so movement of
so possibility to move and to reside. Okay, and what about what are the main, actually, when we are talking, and we as the citizens of the Republic of Serbia, what we have, what are the main rights? When we are talking about the political rights, what will be?
To vote.
Exactly. Do European Union citizens, do you?
They can vote for their national state, but they can vote for...
So we have two levels, right? In non-EU countries, somewhere where you don't have your embassy or consulate, and
the EU other embassy.
Exactly. So it's, do you know what's the name of this right? They have the right of the diplomatic protection, so they can completely if you lost your passport. And is there any possibility to do your issue, but with the embassy of the other member states country? For example, can that be the marriage? it's always something. You lost your passport. It was stolen, or I don't know. Is there any possibility to maybe to do this kind of the event, to organize this kind of thing? Yes, of course, doesn't matter. It can be something bad, or yeah, they can reach any embassy or consulate of any other member states country.
EU citizens can also register their firm and business in any EU country.
Exactly.
So,
yes.
So yeah, they can easily have a business in other EU countries. While if you're a citizen, for example, of Serbia, we cannot do that.
Yes, of course. Also for them, it's more or less easy. They can choose only the country and open in this when we are talking about the corporate law, it's more or less. Ombudsman. Yeah, and does it exist at the European Union level? We have here at the university ombudsman. It's the ombudsman for all of us, professors, and actually for the whole community. And we have on the different levels, and European Union as well has the ombudsman
and the petition.
Exactly. That was I'm waiting just to see. Yes, exactly. That's great. They can use. They have right to petition actually. And what's the another address? European actually Parliament, exactly. Yeah. So that's it. So when we are talking about the European Union citizenship, it's very important now area. Why? Let's start from the beginning. This was introduced by the Maastricht Treaty. So now we are talking about the 1993, actually. EU citizenship is described as the fundamental actually in this year, this area judgment, very important one. And they said here it is additional to, but does not replace national citizenship. So when you are French or Belgian or German, Austrian, definitely you are EU citizen. So the core articles are articles dealing with the EU citizenship. You can find them from we are talking about the articles 20 to 25 of the treaty of the functioning of the EU, and every and some of them they are dealing you can find for example Article 9 of the TEU, Treaty of the European Union. So that's a little bit there in Treaty of the EU and the Treaty of Functioning of the EU. You can find these core rights in both actually articles. And we tried actually EU citizens enjoy. First one, as you said, free movement and residence. This is you can find it in in Article, it's here, from 20 to 25 of the TU. And this one, when we are talking about the free movement and residence, it's Article 21 of the Treaty of the Functioning of the EU. Is directly effective. You can just note, it's very interesting one, as Rothman case, bombast case. Bombast, it will be you can find it later, but it's for the free movement residence from 2002, actually, bombast case. Then what are the other rights? As we mentioned, citizenship of the EU. So we have political rights, Article 11 of the Treaty of the European Union, citizen initiative. Somebody mentioned, you mentioned just European Commission. Why it's here in this area, when we're talking about the EU citizenship, did you heard about this? It's named Citizens Initiative. Actually, do you know what does it mean? Is it? Do you know? Is it? Do you know what does it mean? Actually,
Not of initiative, and that is the new, right?
Exactly.
But it's really hard to actually accomplish it because you need to have all.
Submitted to the Commission and suggest some things to submit proposals for legal acts. That's the possibility. One of the rights. We cannot say that the EU citizens sometimes they are not even aware of these rights, but they are actually have them and they are using them every day. Procedures and conditions to be are determined in the Article 24 of the TFU, but there is a possibility for the EU citizenship if they think there's some issue or question should be treated in the regulation, directive, something. What for them it's important. They need million. Very complicated and it takes time, but that's one of the possibilities. So that's one of the rights as well. And what else? We have Article 20 and 22 of the Treaty of the Functioning of the EU. There is right, as we said, right of citizens to vote and stand in communal elections in the host member state and in elections to the European Parliament. And now I have the question for you. Is it possible, for example, let's imagine one resident, for example, a French family is moving to they're moving to Spain. Can they use these political rights in Spain? Can they vote and stand in common elections in another member states or not?
And for the Parliament, European Parliament.
Actually, they can use it, but they cannot use it twice. Actually, if they are in Spain, they will use it there, not in France. That's.
They cannot use it.
very nice. It's a formality, but it's very actually all of these I say 5 rights. They can use it. They are only common for the EU citizens. They can use it, the last one actually is the making petitions, as we said, making petitions to the European Parliament, and applications. It's a different word, just be careful. Applications to the ombudsman and writing to the, they also they can write to the European Union institutions, bodies. And how many languages do we know? How many languages do we have in official one? How many member states there are? 27. And the official languages we have a little bit less because French is official language already in couple. So we are talking about the 24. The last one was creation. So 24 official languages. So EU citizen can write right to actually protect your right and the member state, different member states, diplomatic consulate. Why it's? I said, well, let's see why importance of these articles. Just to mention. As we already said, the EU citizens enjoy the right to move and reside freely within the territory of the member states through the subject to the limitations and conditions laid down by other EU law provisions. Because there are always some of the conditions. We recently had it was the same for us. We are not, we are not non-member states. We are not a third country of the EU. Yeah, but it was the same. The same rules were for the EU citizens. When the right to move and was recently abused, and why was that? We are talking about which. Yes, but what about the COVID? And the situation was the same, right? That's one of the situation when even for the EU citizens, that's why we are talking about these conditions. There is a list actually in which situation it's not allowed. So the provisions has become increasingly important through the ECJ case law. You talk about this directive 2004, which is important in this area for the gender law, and ECJ case law gives meaning to this actually to these articles. When we are talking about Article 21, for example, of the TFAU, enlarges the scope of free movement and narrows down the derogations. We just mentioned some of them. lawful residence of an EU citizen gives him right to equal treatment and this depend of the other conditions as well. So here you have the I just prepare for you again some of the more or less recent. It's 2004, but they are really judgment. Ionidi is but whereas then that's the last one in this the most recently actually there is Orphanopoulos, and if you need them, it's just important to know what are the landmark cases, and if you need it, you can easily find them and use them for your future work, or I don't know what you will later do, but have in mind that here at least you have the list of the main landmark cases, actual landmark cases in in this area which are dealing today. So the next one is lawful residence of an EU citizen gives a right to equal treatment. So these are really famous. You can, if you Google right now, for example, Martinez Sala, Bidar, Troiani, any of these judgments, you will easily find maybe hundreds of scholar articles. These are really landmark cases, and you can, for your analysis, whatever you need, you can find good analysis and how to say key significance if you need tomorrow in every of these aspects. Just you will see what's the why in which area of the gender law it could be important for you. For example, the first one we are dealing here with child raising allowance, then social assistance benefit, student loan, taxation of the economically inactive. They are not yet. Then in situation where an equal treatment claim is made against a person's own member states, for example. You see, here I just put 7, but they use them for or not only the textbooks of the law, for example, but they are using sometimes the good scholar articles. But what is the main when I mentioned this? Could you tell me? It's related to general EU law, especially to the Court of Justice of the EU. Do you know? Maybe I'm asking, of course, you the lawyers, but maybe the others know. When the judges are in their chamber and they are preparing actually the judgment, what will be for them the main source? Who is helping them for this judgment? Do they have any help? We said in the Court of Justice, we are talking all evening about the Court of Justice of the EU. There are 27 Opšti general attorney, exactly. Bravo. So it's a general attorney. Why they are important? Sometimes we can see the judges of the EU of this court, they have the main salary as the job, but the judges are dealing and actually they're preparing the judgment. And what are preparing? Do you know why are the attorney of general are so important? What is why? and it still has they can raise this number. But why they are so important? Do you have any idea?
Well, they can also suggest a decision.
Actually, they are writing opinions, and they are famous because of these opinions. They are signing by name. These 11 persons are dealing. Actually, they are preparing. They are giving the analysis. How to say? They are preparing for the. It's not a judgment. It's named the opinion, and it's a public for every judgment, important judgments, especially in the judgments where they are sitting in plenum, where we can find 27 judges who are dealing and they are preparing judgment. These are crucial questions, radical questions, and these questions you can find in every 10, for example, 10 years. There is some issues which are burning like this, and then they will really need a attorney general, and this person is preparing. If you you should probably agree, the judges are sitting. They are sitting in chambers. There is a difference because between Strasbourg and Luxembourg court. In Strasbourg court, is there any? Can we find the dissenting opinion? If there is somebody, if some of the judges is not, can we find on the site also? Can we find the dissenting opinion?
We find it on the document.
Yes, but it exists, of course, and you can find it, of course, online, of course, but it exists, of course, in Strasbourg court. My question is for you: does it exist in the Luxembourg court as well? No. When the judges are deciding about the judgment, in that room they are alone. But these 11 persons, attorney general, they are actually comparing to the judges. We can never know actually who was pro, who was contra, how was really at these meetings actually. It's always everybody they sign, and there is no possibility to write this opinion. So they are always. It's always. It depends if it's. Maybe in which court we. Of this court, of the court of Luxembourg, is the primary law, and in hierarchy when we have primary law, secondary, and where is the constitutions of the member states, and where are the laws of the member states. So, and when you look now, there is a possibility that one person, one judge, is dealing and writing the decision, and that's possibility, and it happens in general, not in the Court of Justice of the EU. So these, just to come back to the Attorney General, they are very important because they are signing by their name, and sometimes it is completely included in the judgment, sometimes not, but the judges are following actually these opinions, and they are pretty famous, very famous, and you can find in every, it could be useful for you. Judges were using You can find first, of course, opinion, then the scholar articles, textbooks, every secondary source, directives, regulations, or so. At one place, you can find completely your reference list. For example, for that judgment tomorrow, if you have to compare tomorrow, I don't know, will give you maybe two or maybe you should compare if you need to deal with the judgment of the ECJ, of the Court of Justice. Just go carefully, and you can open and see all their reference list, what they used for that judgment. So let's go to the Rothman case, and we will actually finish today with this and all the others. Actually, I prepared a huge, because it's only this possibility. It was really very. Still cannot have. I can do it in here in 2 hours, but I will send you a really nice packet of the literature, and you can later contact me for everything you need that I can be useful for you. So, famous Rothman case. Is dealing, of course, with the EU citizenship. Here you have factual. I will go now, if you don't mind, quickly. You will have my presentation and everything. So you will have. He automatically would lose his nationality of origin. He was in a kind of situation, and now we are asking what's happening for the what are the situations in which the EU citizens have when they have two nationalities. Actually, what's happened if there is a loss of one, and keep in mind that we are talking we have two nationalities, and like a tool, there is EU citizenship. Imagine the situation if that person, one person, can, if it happens, of course, but if lose both, actually, of course, which are the consequences for the member's family, members. How it's difficult and complex this situation, and you can even analyze what happens. What is important? How did they lose? Was that like this? For example, in Rothman case, we are dealing with the fraud, but it could be something different. Somebody can resign. Everything is okay. It's not broken. Okay. No problem. Unfortunately, it's not broken. So if it is somebody can resign. So there's a very, very different situation for this. This is very interesting case. Now we are talking about when this is happening. Member states control the acquisition of nationality. These states, they must exercise this power with due regard to the EU law. We are talking about something very sensitive, very they are keeping for themselves every member state, not member states, every state in the world, of course. But when it results in the loss of the EU citizenship, they really, the judges, when they are dealing with this, from this case, they really have keep in mind that about the loss or something else. So, and how they will do this? This is crucial, and that's why you have a lot of, you will find the proportionality test. I will not go now, but don't forget, I'm here to explain everything. What you will tomorrow deal with the general EU law. There is one of the most famous, very important principle. It's a principle of proportionality in the EU law, and they regarding its consequences for the individual's professional, be careful, professional and family life. They really have in mind actually the whole picture, not only it was fraud, but what happens with the, for example, minor children tomorrow. If it goes, they will expel. I mean, they really need to measure and how to say, yes, they have to do this proportion. The comparison with the Rothman case and the next one, which one is dealing, very famous one, also with the EU citizenship. It's a Tebes. It's from 2011. And the third one is which you have in this presentation as well. So these three I took as a really landmark, and they can really be useful for you. So when we look at the Tebes expansion in 2019, this test was later refined. Rothman case, proportionality test from Rothman was refined in Tebes, ensuring that even automatic losses of nationality require an individual assessment of the link between the citizen and the union. So this is very important, and you can see, as you know, these judgments are not too long, but they are not very easy, not. One judgment of the ECJ. Go firstly through the opinion, then the judgment, and then you can compare if you need find another reference list. So I will go. So this Rothman case is very famous. I will send you. It's not too long. One of my articles I wrote about. It's part of my thesis as well, the Rothman case, famous Rothman case. But that one article, it will be enough just to have an idea. And if you Google it, you will have, 500 articles minimum on Rothman. Because it's one of the, especially these, for example, Rothman or Vidar, or I don't know, this one, Magnold, or others from this area, which I mentioned today. As I said, in every 10 years, there are cases like this, and it's completely madness. Everybody's, it's completely something, they are dealing with something new. It's a new situation. The judges need attorney of general who is helping them, and of course, academic communities also. For them, it's very important. Of the literature, you should find really the crucial, the good one, and it's easy. Just look as I said, look the literature reference list of the judges. We choose judges or the main textbook, for example, textbook. If you need that as well, please let me know. I have a lot of scanned everything, but I cannot bomb you. I said some of them. Please, I will go slowly to the conclusions and the key, not conclusions, but firstly the key. You have discussion questions. I will not open it now because if you agree, if you have the time, I'm not sure that you have already the time to read and to see. Most of you are not even common with this. Sentences, I will gladly read and correct if there is something. Give you the example. So you have the discussion questions. They are here. How many? You see, 1, 2. Possibility of recovery, fundamental status versus sovereign rights, for example. On then the question, gravity of deception. The test requires weighting the gravity of the offense. There are so many different situations, so the judges really have to wait, and there are so many different situations, and that's why maybe there is no correct response here. Here and for them as well. So you will see that family impacts, especially with this, if we have the minor, it's always red alarm. Its situation is completely. Discussion question number 5, for example. Here is 3. Let's go.
The class code to see. Arab peace positioning as a class.
Nationality results in his deportation, for example. Tomorrow it's another XY person, effectively separating him from his EU citizen children. Imagine if they are, especially if they are talking about the minor children. How should a national court balance the public interest in punishing fraud, because he obtained this the another citizenship of the another member state by fraud, by punishing this fraud against the right of family life? We have two different, completely clear interests. So, and under the charter, don't forget that you always have so many different sources, and you will find all this here. What will be the significance? If you should tomorrow in 1 or 2, a couple of sentences, give for your analysis, or I don't know, written exam or something. Please have in mind that you will at the end write a conclusion and maybe it's a kind of small essay, but put the main the key, how to say, the key takeaways of that lessons, or I don't know what Professor Marinkovic and Krstić will ask you. So in this Rotman case, considered to be a turning point in the evolution of the European citizenship, what will be what is really important actually? We have the proportionality breach. From this case, from 2010, we see that it's not easy job for the judges. It's not symbolic. It creates a legal bridge that allows the court to review national laws that were previously considered exclusive member state competencies. So now the European judges are dealing with something which is the job actually of the national courts, and vice versa, a little bit. So they really have to mind. Tebes expanded the protection to good actors. Here we have some completely different situation who simply live abroad, ensuring they are not stripped of their fundamental status without a chance to prove their ongoing connection to the Union. And the individuals at the center, the shift, the third one, and I will finish with this, the shift from Rothman to Tebes highlights actually the court's insistence that the fundamental status of citizenship requires a highly personalized, fact-basis assessments before it can be taken away. So now we have the situation where the European Union judges, EU judges, let's say, but when I say EU judges, please don't forget that when we say EU judges are the national judges as well. Well, of course, they really use the EU sources and they don't respect EU law, there will be damages for that. Who can suit before the EU court? Yes, and member states as well, but it's rare, especially in the EU law, because why? If the two member states have an issue, they will try firstly to not go before the court, especially not to go before the court of the not ECJ. What is the fourth actually the most important actually? So that's the actually first. It will be first the commission who will suit another person. And please don't forget that it's a huge process. It takes time because commission will firstly give the first deadline, second deadline. It takes really time. It's not tomorrow. It doesn't work. There is something, for example, it could be any problem dealing, for example, with environmental or something. Imagine the problems. And the judges of the ECJ and the General Court, they are in this area for the first time. Actually, they have very very personalized. It's not symbolic. They are creating cases, and they are dealing with the cases, and they are creating the judgments which the idea is to not to change in every 5-10 years, to give the judgment which can later, they are not obliged. It's not like in Anglo-Saxon law to respect and to go from their previous judgments, but they are trying now. They are dealing with for the first time they requires, actually these cases requires a highly personal fact basis assessment, and it's very important actually for them. I will, if you agree, we had a little bit more. I will stop here for today. You will find another one, because here I mentioned with the Rothman case, Tebelj, the second one, but there are so many. For example, in the presentation, to judgments, and we have also the significance of this second one. Why this one is important from 2021, because the ECJ for the first time has explicitly recognized that domestic violence can constitute a ground for refugee status. You mentioned before, I think, and that's when you can put one person, women who is living domestic violence. It marks a significant shift toward a gender sensitive, and now we can see the real intersectional interpretation of, we are now on the EU asylum law, aligning it with international human rights standards. So you see how it's complex, and here I shall stop. I would like to thank you for your time. Thank you very much for your and you will see them. Maybe it can be useful, especially for those who are Erasmus students. Maybe they cannot print. May I give you maybe 2, 3 more? Okay, if you are in touch with the others, yes, please. But I will send you as well. But you can use sometimes to have in the paper. And it's not goodbye. Keep in touch, and please let me know if you have some problems. If you need something from the taking. Yeah. Please take it. I don't need them. Yeah, for the others, if you are in. Yeah, please take home. I will. You can give them. You can use it tomorrow, maybe. I will send you, of course. Please, for all of this, I printed for the group who is here. These are questions which you can find in the presentations. And it could be good. You can, if you are inspired, you can maybe choose 1, 2, 3 of them, or maybe all in 2 or 3 sentences. Do it and send me. I will gladly see what do you mean, and how do you understand, for example, these cases, actually dealing with the EU law, especially with the EU law, and whatever you need. Otherwise, I'm here. So good luck for your exams. It will be from exam period. Actually, all our cathedra, we are having the lectures Serbian here from the first to the last. Actually, we are sleeping at the faculty. I mean, we can see if you are interested for the consultation. But I suggest you write me, as I'm almost every day at the faculty, and we can work on only issues which you are interested. I don't know, especially on the EU law. I'm not expert in this gender law, but I will gladly help with you all the others, whatever you need, actually. Thank you very much. It was long, it was complex, and I hope that I helped you a little bit. At least you will have in 3 presentations an idea how it works, especially in the EU law, with the Court of Justice of the European Union. A little bit of remedy. So thank you very, very much. Thank you again for your patience and
Thank you, Professor.
Hvala, javite se, molim vas, za što treba za dalje, posebno za evropsko pravo. Svako dobro, prijetno. Thank you very much. Bye bye.
Goodbye.
Prijetno, doviđenja.